Hello, I'm John Vermillion. I am an elder law attorney in Dallas, Texas, and an estate planning attorney. I am a sponsor of the Elder Care Channel, and I want to talk about financial powers of attorney. We normally refer to as statutory durable powers of attorney in the state of Texas. Now, I always admonish my clients that when we do estate planning, we want to incorporate powers of attorney into the estate plan, whether it be for a trust or a will. However, there is a trend among financial institutions in particular not to honor financial powers of attorney. Now, this is very disconcerting because at the time of need, we sometimes cannot transact business when a client is incapacitated and the family members are trying to use the power of attorney to transact business. Now, why in the world would a financial institution not honor a power of attorney? Well, first of all, Texas law does not require that a power of attorney be honored. It's not a requirement. Therefore, the financial institution is within their rights, although it's a very inconvenient right to exercise, not to honor the power of attorney. What are some of the excuses that we hear from financial institutions? Well, often we'll hear a financial institution say, well, we only accept originals. Well, obviously the client will have one original, but if they're doing business or the agent is doing business at a variety of institutions, they're not going to have an original for every institution. So that's extremely inconvenient. And we don't require the recordation of powers of attorney anymore in the state of Texas, so getting a certified copy is often difficult. One solution is to obtain a true copy from the attorney or the notary public that notarized the power of attorney. This is one solution. Also, we hear that financial institutions will often say, we only accept our form of power of attorney. Now, this is extremely inconvenient because if they only accept their form, the client may not be in a position to execute that form at the time of need. So that doesn't work. We've also seen financial institutions say that they won't accept a power of attorney if it's older than 6 months old, or if you have a client who signed documents 5 years ago and is now incapacitated and cannot sign new documents, well then you can't provide a power of attorney that's newer than six months old. We've also heard financial institutions say the exact opposite, that the power of attorney is too new, that there's some question, maybe perhaps the client's signature is completely different on the new one than the old one because the client's health has deteriorated over time and their signature has changed, perhaps gotten shakier or a little less legible. So we have that problem. Another problem we have with powers of attorney is that often they're based on incapacity, and a bank or financial institution may not honor a power of attorney if they don't have evidence of the incapacity of the client. So this is just these are just examples of a trend that can be very troublesome. So one solution is to manage assets through a trust. And a bank will always honor the position of the trustee where they might not honor the position of a power of attorney. The trust will be a much stronger document. And even though there may be modest size estates that perhaps don't need the bells and whistles of a trust may still be a better way of managing the estate in a time when powers of attorney are not being honored. So I hope this is helpful. Thank you.